I own O'Connor Finley Law. We are a divorce and custody law firm in Massachusetts. Massachusetts is very, very small, so we practice in almost every single county that's out here. And I have a TikTok, obviously. She has a TikTok. So I think it's going to be really interesting to hear some of the differences. So I'm excited about this because I know when we do jurisdictional issues and we have another state that we're trying to figure out, it can be so foreign and you don't understand, well, why are they doing it that way? So I really appreciate you doing this because I think it's pretty interesting.
Yeah, and the laws are so different. I think you're probably the fifth attorney I've spoken to from a different state, and it's interesting because one part usually is majorly different, and the others are similar but still different. So I think it's important for people to understand. So let's jump into children born out of wedlock. What rights do mothers or fathers have to children born out of wedlock in Massachusetts?
So in Mass, mom has all the rights. So even if dad signs an acknowledgement of paternity, that does not give him necessarily legal rights or rights to physical custody of the child. So it's really important if you're having a child and you're not married, one, always get the paternity test, and two, always make sure you're getting into court to protect yourself, because I've seen too many situations where the parents are getting along and everything's great, but then as soon as the relationship breaks down, mom really does have the control. And even in situations where dad, for one reason or another, has become the primary care parent, when mom suddenly wants the child back, there's nothing to say that they can't. And so the police will
Yeah.
step in and say, no, the child has to go with mom. And then it's a rush to the courthouse. So it's really, really important, to protect yourself. I do see the courts here when a parent comes in with that, they're giving dad's legal rights much faster. It used to be you had to wait until the end of the case, and I am seeing them give out legal custody, like joint legal custody on a temporary order more often.
Yeah, so we're similar. So even if you sign a acknowledgement of paternity at the hospital here in Georgia, the only thing that allows is for the mother to go to child support services and put the dad on child support. But for the dad to have any custodial rights, he's got to file a legitimation and seek that in the court, either legal or physical. But I tell people all the time too, I'm like, don't wait to do this until you hate each other. Do it when you're getting along and y'all agree on what the schedule should be, because it's so much easier for then when there is a disagreement, say, hey, this is our parenting plan, and we're going to stick to it.
And the other thing I've seen here, and again, I'm sure with you, or I don't know exactly how your cases get assigned, but in our courts, a case usually gets to assign to a judge and it stays with that judge. So unless there's judges changing benches, it's with the judge, whoever is there. But every judge is a little bit different with how they handle it. So I've seen cases where the dad files for custody and then mom realizes they're filing for custody and maybe dad didn't have an attorney, so they don't get in right away. And what happens in that interim, even if they had a parenting, like a set parenting schedule that they were following on their own, a lot of times mom will say, oh, well, now I only want you to see the child, 1 hour or one
Hmm.
night, or maybe not at all. And then you get into court and the judge says, 3 months later, well, this is what you've been doing for 3 months, so this is what we're going to keep. And it becomes very, very difficult to build that back up. Again, every judge is a little bit different, but I have seen that. So I completely agree. Do it while everybody's getting along.
Definitely. Do the judges in Massachusetts have any legal authority to deny a father's rights? So here in Georgia, the court does have, it doesn't happen very often, but the judge can say, sorry, dad, you didn't legitimate in time. You've never financially contributed to this child. You didn't build a established relationship with this child. The judge can say you're not going to have legal rights to this child. Is that a option that judges have in Massachusetts?
It's an option, but them doing it is so difficult to get. Typically, the only time that they've really terminated a father's custodial rights to a child or the parental rights is if they haven't been involved at all. Maybe they've been in and out of jail, and mom has a new husband who is willing to
Yes.
adopt the child. But unless there's somebody who's willing to step up, it's the court will look at it as might be a piece of crap, but he's better than nothing, which
Yeah.
may not be true. But unless there's somebody else there, I haven't seen the court do it very, very often.
Yep, we're in a similar boat. The step parent adoptions, it happens quite frequently. If you can show that, the step parent's trying to adopt before the biological father has taken any effort to try to have a relationship with this child. But other than that, the courts really don't like to do that unless they absolutely have to. So in Massachusetts, you can then be on child support and paying child support for a child, but still have no legal rights to that child.
Correct. So we have basically a child support enforcement action, which they just enacted a law that does allow the court to give out a parenting plan and leave custody through that. It used to be that you could not get it, but the parent has to ask for it. And a lot of problems, especially when it's just a child support case, they're doing it on their own. So they don't know what they can and cannot ask for. And it's usually not something, the other parent's like, hey, you want to share legal custody with me? Usually one person wants that to themselves. So then we have what's called, if there is a paternity acknowledgement signed, you do a custody, child support, and parenting time complaint. Whereas if there is no voluntary acknowledgement, you have to go the paternity route. But there's just child support that DOR, our Department of Revenue, they get involved with that only deals with child support. So there's kind of like 3 prongs where you can go with it.
So we've got some questions on this topic or similar topics, and we can answer them before we move on. One of them is in Massachusetts, never married, positive DNA test, but he still has no rights. He doesn't even care to. And she said, my son's father makes no effort at all, but there is a step parent, but there is no step parent to step up. So under that situation, it sounds like she would have full legal and physical custody.
Yeah. So if there has been no court order, if they just did a DNA test on their own, that is not enough in Massachusetts to prove paternity. I'm assuming here that there's no child support order as well. So if there's absolutely nothing, again, dad has no rights until he goes to court to try to get him, or mom goes to court to try to get child support, and then dad counters, basically saying, well, then I want some sort of parenting schedule and custody. So the question is, so because dad makes no effort, but there's no step parent, in Massachusetts, I don't think that would be enough to terminate. Right now, there's nothing, so you hold all the cards. But if you go into court, they should at least be paying child support. So.
Yes, definitely. The next question is, how does out of wedlock work if we move from our state to Massachusetts? So I guess the question would be, if you have a child out of wedlock in, let's say, Alabama, and then they move to Massachusetts, how would Massachusetts recognize that relationship?
So if by we were just talking about mom and the child, or if you're talking about the family unit, if you're talking about, mom and dad are together and they have a child and they move to Massachusetts, it's the same. And even if not, if mom, and I don't know for Alabama, I could only speak the other direction, but if mom and the child come here and they've lived here for 6 months, our 6-month mark is what hits our home state jurisdiction in relation to the state having control over the child. If mom was escaping Alabama for domestic violence reasons and she needed an emergency order in Massachusetts, we would have the authority to do that only on a temporary basis. But it's not until that 6-month mark that we could really do much of anything. So that's how it would work. If it were the other direction, so if mom and dad were in Massachusetts and mom says, hey, I'm taking the child and I'm leaving and going off to Alabama, here in Massachusetts, dad could file for custody as well as an emergency motion stating that mom should not be able to leave with the child and the child needs to stay in Massachusetts. So I know that could happen. I don't know what Alabama's rules are, but that could happen on the converse there.
Yeah, and that's similar to us as well. We would give full faith and credit to an order in a different state. So if the parties were not married and they had an order from a different state, then obviously when they came to Georgia, we would domesticate that and give full faith credit to that order. But the laws here would remain the same. So if you had a child out of wedlock and the whole family unit moves to Georgia and you've been here for 6 months, then Georgia would have jurisdiction over that child. Let's see. We have another question that says, Dad wants, where did that go? I think it said Dad wants every other weekend, but he refuses to take the child to extracurricular activities during his time. Can that be addressed in the parenting plan? And here in Georgia, absolutely. And we do address that. Sometimes we'll put in the parenting plan that both parties are required to take the children to activities during their parenting time. And if they can't, they give the other party the option before the child misses. What about Massachusetts?
Yeah, I think we're exactly the same with that. A lot of it just depends on what you ask for. So on that, if it wasn't written in and dad already had every other weekend, but you saw a situation where dad wasn't bringing the child to their extracurricular, you could file a modification asking for that language to be put in, or maybe asking for the weekends to switch if the sports or whatever the activity was only falling on his weekend rather than the other weekend. So it really depends on what you're asking for and what you're looking for. And we've even built into some of our agreements that if the other parent is the one who has to take them, there's some sort of monetary, I don't want to say reward, but some sort of monetary part of that to help cover gas, because then you're just acting like a babysitter. So
Yeah. And I do think it's important for people to, like, the judges are going to weigh, are you overscheduling these kids to make it where they don't get to exercise their parenting time? Or is the other parent just being a jerk and they're involved in, baseball and they just don't want them to do baseball on their weekend? So there is a line there between what's in the best interest of the children and are you trying to control the other parent?
right, and we've seen that too, especially when you get into like competitive gymnast, competitive soccer, horseback riding, these extreme sports where one parent just goes and signs them up and they don't care how much it costs as long as the other parent, has to pay for it or has to take them. The key in family law is reasonable. Everything has to be reasonable. And usually we do build in up to 2 extracurricular activities at a time to circumvent those where the kid's just enrolled in something every single night.
Yeah. And I think people have to understand too is the reality, if you're together as a family unit, what your kids' activities look like might be different if than when you are separated. And so somebody asked, how many extracurriculars is too many? And I think that's going to depend on the child and on the situation, because sometimes even if you're in two and your two is competitive gymnastics and travel soccer, then you're probably 7 days a week right there, just between those two activities. And so sometimes you've got to use your discretion as a parent, but in general, I think 2 activities is reasonable as well. What about, let's talk about custody. In Massachusetts, is there a default to 50-50 custody? Is that a starting point? Is that the norm? What do you usually see for physical custody of children?
So if we're talking unwed parents, they really don't start with 50-50. A lot of times if the dad can show that he's been heavily involved, you might get that. But it's more so in a marriage situation. If you're going through a divorce and you're trying to work out a parenting schedule, that the default typically is 50-50. But again, some of it depends with every judge. I think our laws is that should be the starting point, but then you can deviate from that for a whole list of reasons. The judges here still sometimes there's a divide within our judges where some judges will look at it and say, well, what was the status quo during the marriage? Was one person the breadwinner? Was the other person staying home? And if that's the case, we're going to take that into consideration. Other judges say, well, divorce is a starting point. Everything's going to be different. So we're not going to necessarily hold everybody to what was going on during the marriage because they were doing what worked best for the marital unit while it was together. Once they get the divorce, now we're dealing with a whole different ballgame. So some of it just depends on the judge you walk in front of. So it's really important to know your judge.
Yeah, it is always really important to know the judge and know your county. Here in Georgia, our statute is primary, secondary. And so we do have law that supports the judge to be able to do joint physical custody. But by far, the judges, when you go into court here, if you're showing up before a judge to decide what's best for your kids, it's very rare that they're going to decide 50-50. And what most of the judges say at that point is, look, if y'all can't decide that 50-50 is best for your kids, how am I supposed to do that to say that y'all have to share these kids 50% of the time when y'all can't agree that's even what's best for them? Because it does require so much communication, so much, logistics. Obviously, you have to live within a certain area for that to work. So in general, it's definitely not the default. Now, more people are agreeing to it than I've ever seen happen before, and I think that's great. That shows that there's been involvement by both parties, but if it's up to a judge, it's not probably going to be what the judge orders. Unless it's been the status quo and someone's just being a jerk and doesn't want it, even though they've been doing it for a very long time, which happens too.
Yeah, because we also see we have one of the things that the court looks at is how well the parties communicate, and I think you kind of referenced that. But what what kind of happens there is one parent just becomes difficult and then says, well, we can't communicate because we can't talk to each other. And the courts here do look at that. And I've seen parents who are the person who's responsible for the lack of communication actually lose custody.
Yeah, I have to. And the court's going to expect that you can communicate like an adult and not pass messages through your kids. And that's a huge part of custody here as well. We have a question. What's the best way to submit text messages in Massachusetts so it can be evidence at a hearing?
Um, so text messages can be hard because especially when people start screenshotting them, if there's any chance that anything's missing, there can be an objection that it's not a complete record. So I know there's programs for different phones that can pull the text messages off and they're in line. The problem with everything is it's very easy to delete text messages, and it's
Yes.
not as, it's not the same as phone records where you can go to your statements and you can see exactly who called, regardless if somebody's swiping left and deleting it. Text messages has that argument. The courts here have really started pushing either our Family Wizard or App Close as communication devices because of the fact that you can't delete things. So you can definitely get text messages in. I've used them before, but usually if I'm on the other side and something's coming in, I'll object to it because it's not a complete record. But I've also seen judges actually take somebody's phone and start scrolling through it on the bench. So you can just try your best.
Yeah.
But make sure if you are screenshotting it, make sure it has the end of the first message, that you can see where it's ending. It needs dates, it needs times, and you need to show that you have that complete record if you're walking in with like 100 pages of text messages.
Yes. And here in Georgia, at least, the text messages have to be messages that you've sent so that you can testify to them, right? So if you've gotten messages from someone you should not have or you don't have access to, then you're not going to be able to lay a foundation to get those in.
Yeah, for here, so within our temporary order hearings, a lot of times they're not evidentiary hearings, it's just oral arguments. But the judges sometimes do look at text messages. I always advise my clients, we're going to bring them in and we're going to kind of use them as props, which the judge may or may not look at them. But if the judge feels as though there's something that could really persuade them, a lot of times they'll say, well, let me see that. Not always, but it's very different than at trial. Trial is way more formal, and there might be things you're able to get in throughout a temporary order hearing that you're not going to be able to get in at trial.
What would your one piece of advice be, or maybe a few pieces of advice for people to do if they're in the midst of a custody case to better their chances at getting primary or joint custody?
Um, your communication should be through some sort of program that can't be manipulated. That's definitely one. It so much depends on the circumstances. Like I have a case where we want during every exchange for that to be recorded because the child's behavior changes, and it's very different to be able to describe that than to have it on video. So each case is going to be a little bit different. Probably I'd say good record keeping, but then that's not always the case. If it's a question of how much time do you have, and I've seen this play out in cases, don't just keep a calendar. Send a text message to the other person saying, confirming that I had the child on this weekend from this time to this time, or whatever that is. Because then it's not just something you're creating on your own, you're sending it to the other person. And if they don't come back and say, no, that you did not have the kids during that time, it gives you a little bit more credibility. Because everything in family court is basically a he said, she said. So anything you can use to boost your own credibility and show that what you're saying is true, I think that goes a long way in our court.
Yeah, I agree. And be involved as much as you can and as early as you can. Don't leave 100% of the parenting to the other parent. Even if you are the working parent, you can still be involved in being copied on things from the school, or being involved in making sure the doctor knows who you are, or the teachers know who you are. A lot of the times people just fall into these roles, and there's nothing necessarily wrong with that. But then when they get a divorce, all of a sudden they're like, well, why can't I have joined? And you ask those questions of, well, who's their doctor? Where's their dentist? And well, I don't know. I've never taken them, right? That wasn't my job. And so a huge piece of advice that I always give people is make sure you're involved as early as possible and as much as possible in your child's life.
Yeah, I think that's a huge point, because on trial, that's one of the questions I go through with the other side. What's their favorite color? What sports are they in? Who's their coach? Who's their teacher? What grade are they in? What school are they in? And it's always amazing to me that people who are looking for shared physical custody and they want the parenting schedule, they don't know this basic information. So how are they going to basically take over half of their child's life when they have no clue what's going on in it?
Definitely. Let's see, we've got another question. Can you request that weekend homework be done with a parent who has them that weekend? I have definitely put this into parenting plans before, that whoever has parenting time is responsible for making sure that the child does their homework on their parenting time, especially if you have like weekday parenting time where they're returning them at like 7 or 7:30 p.m. You want to make sure your kid's homework is done. I have two kids, and homework is a battle. And if they were coming home at 7:30 or 8 and hadn't done their homework, like, our house would be crazy. What about you?
Yeah, it's exactly the same. If a parent isn't getting their homework done during the week, during the weeknights, or during the weekend, it might be something where that justifies a complaint for modification to either reduce the parenting time or maybe have them come home earlier on Sunday so that they can get the work done. Now, the thing that stinks about it is that really leaves the burden up to the person who has custodial, who has primary custodial rights to the child. And sometimes that doesn't seem fair, where you're the one who always just has to be the person who's making sure the work gets done. You're the disciplinarian. It's not a fair situation, but that also, the way that Massachusetts looks at it is, if you're taking that role, that is your role. So it is your burden. That kind of stinks, because you can't make the other person do what's right, but you can minimize the amount that they're able to not do the right thing.
Yeah, definitely. So let's transition a little bit to divorce. Is Massachusetts a fault-based state for divorce? Do you still have grounds where adultery matters, or behavior, or is everything just irreconcilable differences or irretrievably broken?
For the most part, you're going to file irretrievable breakdown of the marriage, just because it's so much easier. If you're filing on a fault basis, which you can still do in Massachusetts, but if you're doing that, you're typically looking at, this case has to go to trial. Because in order for if the other side's probably not going to agree to, oh yeah,
Yes.
let me agree that, I committed adultery and that's what we'll base it on. So then, we have people come in that they think that doing fault grounds is going to get them more in the divorce. But here in Massachusetts, adultery morally doesn't matter, yes. But for the most part, it's not going to matter in relation to a property division. It's not going to matter in relation to alimony. The behavior component of it is more so, let's say it was somebody that, they're cheating on their spouse and they buy an apartment or another house, and it's a significant amount of money. But we also had one case where the husband had that whole situation and had bought like I think it was a condo in New York for the person he was with. However, our client had a huge purse, she was buying like Louis Vuittons every other day. The judge looked at it and said, well, you guys both have your vices and you've spent about the same amount of money, so I'm not getting into it. So cheating doesn't do as much as it used to. And it really comes down to when I hear somebody coming in and saying, I want fault, it's okay, is this an emotional decision where you just want them held responsible for their actions, or are you looking to get something out of it? Because for the most part, you want to get in and out of divorce as quickly as possible. You don't want it to have to go to trial. And that's really the difference.
Yeah, we're similar. Most cases are irretrievably broken, but we do have 13 grounds that you can file for. But a big difference for us is if the affair is what led to the breakdown of the marriage, then you're statutorily barred from alimony, from getting alimony. So it can be, especially in a high asset, high earning case, it can be a huge issue if, say, the wife was stay at home and the husband worked and she had an affair and that's what led to the breakdown of the marriage, then she's statutorily barred from getting alimony. So that can make a huge difference, obviously, in a case. The courts can consider it for equitable division, but again, it's usually if it's egregious behavior and they're liquidating the marital state for this affair. Other than that, the court doesn't really want to get into it very much of the behavior, because I think the court also recognizes that when someone has an affair, there's likely other things as well that happened before that, and the court then is digging into this very deep hole of, okay, how did we get here and what happened, and trying to figure it out. And they don't really like to get into that. The goal is they want to separate these people moving forward as efficiently as they can.
Yeah, so we don't have that where if there's any cheating, it can play into whether or not somebody would have to be liable or be able to get alimony. Even if you cheat, you can get alimony here. So
Yeah. So I bet people don't like that if they're the one paying, probably.
not very much at all.
So I have one more question, and then we've got a few more in the chat before we go. The last question I have is about relocation. So let's say that somebody was divorced in Massachusetts, or they have a custody order already in Massachusetts, and the primary custodian, or if they have 50-50, one of the parents want to relocate. How does that work? Does the non-moving party have to file a modification, or does the moving party have to file a modification? What's typical for that?
So we usually build into our separation agreement. So if we're talking a divorce or a custody and there's been something already there, if they've had an attorney and they've been a good attorney, there's usually some sort of process that's built in case that situation comes up. Now let's pretend that there's nothing and mom just says, hey, my parents live in Florida, I want to move to Florida. Now, if she can get dad to agree, I would recommend getting that in writing, having it notarized. If they agree, there's nothing really that they have to do. So they don't have to go to court. The only thing that would come up if then dad changes his mind and says, oh no, actually, I don't want you to move to Florida. And then he can go to court and basically stop the move from happening. And then it becomes a relocation issue. Mom could proactively file something in court that says, I want to leave. And if dad signs it, then she's good to go. Typically, if there's a question of whether or not the other parent would allow it or the other parent is saying no, you should file. Don't just leave with your child. I've seen, children get taken away because one parent leaves and then the court orders for the child to be returned.
Definitely. And here, at least here, the judges are really going to want to see a compelling reason for the relocation. If the child has a established relationship with both parents, the court's going to weigh that pretty heavily against the factors to move. And so what I have found is, just a slight increase in income for a job offer is probably not going to be enough for the court to say, hey, yeah, that makes sense to move the child away from everything they know and their other parent if the other parent's very involved. How do the judges feel in Massachusetts about relocations?
So we have two different burdens. One is that the parent who wants the relocation has to prove. One is if it's a situation where one parent has primary and the other only has limited, like it might be an every other weekend and one dinner visit, versus if the parents share parenting time fairly equally. The burden is much higher when you get into that shared parenting schedule. But one of the factors they look for is this move to prohibit the children from having a relationship with the parent who's here. There's a whole bunch of factors that play in. Again, the burdens are different. Some of it, again, depends on the judges. You know, some judges are more willing to, if it's a mom and she has a much better financial situation. Like I had one where mom and the child wanted to move to Florida because she could get college paid for out there. She had grown up in Florida. Her family was from Florida. She could have it paid for out there. And dad wasn't the best dad, you know, and the court allowed her to move. So it really depends. I've seen other cases, again, because Massachusetts is so small, we have these cases even if we're just going across the border to Rhode Island or New Hampshire or Vermont, like anywhere where we're right on the border, we see these pop up very often. And even just those small moves, because of the fact jurisdiction changes once the child's been there for 6 months, there's a lot of judges who, unless there is a really, really, really strong reason, they're not going to allow it. And getting into GAL reports, you know, where you have to have something,
Yep.
it can be very, very expensive.
All right, three last questions from our chat. I picked a few. One is, how do I protect my child from the father's addiction? I guess somebody was probably sober and then got back into an active addiction. Here in Georgia, there's a lot of things. The court has broad discretion on what they can put in a parenting plan. So depending on what the addiction is, there's obviously very different paths that could take. So for alcohol testing, we use SoberLink devices very often where it's a breathalyzer. If it's a drug issue, it could be where there's required drug test. It could be required that they do a step plan where they increase their parenting time. And if they fail any drug test, that they go back and revert to step one. We've got a lot of ways that we can, as attorneys, craft a plan that's going to protect the child and explain to the court why that plan is appropriate. So ours is pretty flexible based off the situation. What about for you, Heather?
We're pretty similar. So we're like hair follicle testing. You know, normally there will be something where they have to do hair follicle testing every 90 days in order to basically set that base standard and then make sure that they're staying clean for a certain period of time. We have supervised visitation. The problem with that are the centers are so backed up that sometimes it just makes it where the parent who has the substance abuse issue isn't getting parenting time because of how backed up they are. Supervision with a family member, if there's somebody that the parent who doesn't have the substance problem trusts enough to make sure that they're, you know, if there is a problem, they're going to point it out. That's a possibility. The step up plans we definitely see. I think, you know, and we've seen cases where the judge says enough is enough, because a lot of the problems with substance abuse is that it becomes out of their control and they fall back. And what that does is create an inconsistency for the children, which isn't good either. And so if, you know, we've had the argument, we've had it against us, depending on who we're representing, that the inconsistency for the child with somebody who is facing, you know, really struggling to be sober, which that's a little bit of a different area than somebody who's committed to sobriety and they just have to prove it. If somebody continues to relapse and continues to use, then it becomes this isn't stable for the child, where they're suddenly seeing their parent and then they're not, and they don't know what's going on. And it's very hard to be able to explain that to a child. So in those situations, it might be where they have to prove their sobriety for a period of time before they even get the chance to get in that step up program again.
Yeah, and as a follow-up question, somebody said, what if the spouse of the father is the one relapsing? And in my experience, if the step parent is the one that has an addiction problem, that can be a really difficult position to be in, because it's, number one, difficult to prove, right? What authority does the court have to make this third party test? I have had cases that it's very rare where the judge will say the children are not permitted to be around this particular person, but that person has to be pretty egregious because the court's going to allow and trust the parents to do what is in the child's best interest if the parent's not, a user or an addict. But that could make a case very difficult.
Yeah, same thing here. And I think it's not as infrequent to get some sort of order that says the children aren't allowed near this other person, but there has to be some sort of hard proof, not just a verbal allegation. If the other parent was, or if the step parent was arrested and there's some sort of record of it, if there was an OUI, if there's something that shows other than this is what I hear, I'm hearing that they're falling down drunk every single night or they're leaving cocaine around the house. Even those allegations here, I think the court will often take more serious than not. But if there's something definitive, it's usually pretty easy to get an order that says they're not allowed around the children.
Yeah, and the last question is somebody said, does the court recognize financial abuse such as not paying child support on time or even at all? Here in Georgia, obviously not paying child support is a contempt of court and the judge